Hello friends, in the series on the income tax cases, today we will discuss a very important case which is based on a Central Board of Direct Taxes Circular number 1 of 2011 which describes the various monetary limits for completing the assessment by the income tax officers and by the assistant commissioners. If we analyze broadly the circular number 1 of 2011, then according to that circular, the assessment in the case of an assessee who is a non-corporate assessee and having a income more than 20 lakh is to be completed by the Deputy Commissioner of Income Tax. In the present case, the issue before the Honorable Delhi I.T.A was that whether a assessment is valid by the Deputy Commissioner of Income Tax under section 143 subsection 3 on the basis of a notice issued under section 143 subsection 2 by the income tax officer who was not having the jurisdiction over the assessee, and especially where there is no transfer order under section 127 for transferring the case from the assessing income tax officer to the Deputy Commissioner. This issue has been taken up by the Tribunal in the case of Vipul Mittal versus Deputy Commissioner of Income Tax, and this case is reported in 131 I.T.A, page number 621, and the date of the judgment is 15th January 2025. In the present case, the assessment year is 14-15. The assessee is a non-corporate assessee having income above 20 lakh. The notice under section 143 subsection 2 was issued by the income tax officer for the assessment year 14-15. And then after realizing that he cannot complete the assessment because the income of the assessee is more than 20 lakh, so he transferred the file to the Deputy Commissioner without the valid order under section 127. When the file was transferred to the Deputy Commissioner of Income Tax, he didn't bother to issue the fresh notice within the limits under section 143 subsection 2, and he completed the assessment on the basis of the notice issued by the income tax officer. When the assessment was completed, some additions for the penny stocks were made. When this matter was before the AO, the assessee didn't raise any objection regarding this monetary jurisdiction, and even before the CIT appeal, the assessee didn't raise this monetary limit jurisdiction, and the CIT appeal dismissed the appeal of the assessee. When this matter was before the tribunal, the assessee first time raised this jurisdictional point, and the tribunal accepted to listen this ground on the basis of the Supreme Court judgment in the case of National Thermal Power Company Limited versus Commissioner of Income Tax, which is decided in 1998 and which is reported in 229 ITR at page number 383. And according to that judgment, any jurisdictional point which do not require new facts on the file and which matter goes to the root of the matter can be heard at any stage. When this matter was heard by the tribunal, the department come very heavily and said that the assessee has not raised the point of the jurisdiction within 1 month from the end of the month in which the notice was issued. So the assessee now cannot raise this ground first time before the tribunal. After hearing the contentions of the revenue on this ground, the tribunal said that section 124 subsection 3 only applies where there is some conflict between the assessee and the revenue on the basis of the territorial jurisdiction, since in the present case there is no dispute that there was dispute on the basis of the monetary jurisdiction and not on the basis of the territorial jurisdiction. So the section 124 subsection 3 would not come to the rescue of the revenue. And secondly, the tribunal said that in the present case there was not a valid order to transfer the file from the income tax officer to the Deputy Commissioner, and even the Deputy Commissioner has not taken the pain to issue the fresh notice under section 143 subsection 2 before completing the assessment. So from the facts of the case, the department plea that the assessee should raise this ground of jurisdiction within 1 month will not come to the rescue of the department and quash the assessment proceedings. Friends, this case is very important because in a number of the cases this happens that the notice is issued by one officer and the assessment is completed by other. So, first of all, it is the duty of the assessee that when the notices are issued, they should very minutely observe this point that whether the notice has been issued by the jurisdictional assessing officer or not, and they should raise this ground within the time limit. At the end of this video, once again I am repeating the name of the case. The name of the case is Vipul Mittal versus Deputy Commissioner of Income Tax, and this case is reported in 131 I.T.A. Tribunal at page number 621, and the date of the judgment is 15th January 2025. Thank you, friends.